Good afternoon. Good afternoon. Welcome, everyone. I'm David Levy. This is the Brainerd Currie Lecture at the Duke Law School, one of our signature lecture series. It's named in honor of Professor Brainerd Currie, who taught contracts, admiralty, and conflict of laws at the Duke Law School from 1946 to 1949 and from 1961 to 1965. Professor Currie was an admired scholar and a beloved teacher here at Duke, as well as at several other law schools, including the University of Pittsburgh, where he served as dean, and the University of Chicago, where his son David also served as a member of that faculty with great distinction. Professor Currie was a preeminent theorist on the conflict of laws, and he was a gifted teacher. One of his students wrote after his death that ideas were the essence of his classroom hour. It is fitting then that Duke has seen fit to honor him for these many years with this distinguished lecture series. The series began in 1967, and it has brought scholars of the very first rank from around the country to this law school to address a wide range of issues. And this year is no exception. The lecturer is a distinguished judge on the Ninth Circuit Court of Appeals and a wonderful scholar and teacher. He's also my very good friend, and it has been a great pleasure to welcome him to Duke Law School and his spouse, Linda. Our own constitutional law professor, Ernie Young, will introduce Judge William A. Fletcher.
Well, one of the nicest things you sometimes get to do in this business is share the people who have been a formative influence on you with your own students, and it's our pleasure to do that today. I'm very glad to welcome Judge William Fletcher here and his wife Linda to be with us. Judge Fletcher is the Richard W. Jennings Professor of Law Emeritus, although he seems too young to be an emeritus person, at Bolt Hall Law School, which I guess they've renamed Berkeley now. He is a Rhodes Scholar, a former clerk for Judge Stanley Weigel and for Justice William J. Brennan, and a judge of the Ninth Circuit. He is also the first person I ever talked to about law teaching when he came to the Supreme Court to talk to clerks who might have an interest in that direction, and he has been a great encouragement in that regard all of my professional life in this business. If I had to name 5 law review articles that I wish I had written instead of the person that actually wrote them, 2 of them would be by Judge Fletcher, including my favorite law review article of all time. The only criticism that I have of Judge Fletcher is that he has never had much of a gift for titles, in my view. So my favorite law review article of all time is called The General Common Law and Section 34 of the Judiciary Act of 1789, the example of marine insurance. My second favorite, perhaps, is a historical interpretation of the 11th Amendment, a narrow construction of an affirmative grant of jurisdiction rather than a prohibition against jurisdiction. Judge Fletcher apparently has been consulting with Madison Avenue because today's lecture has the catchy title of Whose Courts Are They? Federal Courts in an Age of Federalism. Judge Fletcher is truly one of the people I would very much like to be when I grow up, and it is a pleasure to have him here.
Thank you, David and Ernie, for that gracious welcome and introduction. I want to say a word about first David and then Ernie before I begin. David's loss to the federal bench is your gain, as I'm sure you know. He was one of the outstanding judges of his generation, and I'm sure he is on his way to becoming one of the same outstanding deans of his generation here. Ernie, I have something else to say. Ernie is at once one of my greatest successes and one of my greatest failures. The success part is I knew almost immediately that he would be a wonderful teacher and scholar, and I tried to recruit him the first time I met him. I've tried to recruit him the entire rest of his scholarly career, and my failure is that I have never been able to do so. I thought that we were about to get him to come to Bolt, or I should say the school formerly known as Bolt, when he, persuaded by your new dean, Judge and now David Levy, or Dean Levy, persuaded Ernie to come here instead. And I had no choice. If I wanted to talk to Ernie, I had to come here, hence my presence today. And one more, this will be an apology to my dear brother-in-law, Tom Rowe, who traveled all the way from California to be here this week. I hope there were other events other than my talk, Tom, that brought you here.
I wouldn't be here anyway.
Okay, I'm relieved to hear that. I'm deeply honored to be here at a lecture given in honor or in the name of Professor Brainerd Currie. As you just heard from Dean Levy, he was here both at the beginning and at the end of his career. He was truly an intellectual giant, transforming the field of conflict of laws and making closely related contributions in other fields, including subject matter jurisdiction, forum choice, and admiralty. I'm honored to give this lecture, and because my lecture touches on some of the themes of his work, I like to think that he would have found it of some interest. Samuel Adams, the Massachusetts patriot, did not like the newly proposed Constitution. He particularly did not like its introductory phrase, "We the people of the United States." The phrase signaled very accurately a departure from the Articles of Confederation, which the Constitution was to replace. The constituting authorities for the Articles of Confederation had been the states that had individually signed the Articles as independent countries would sign a treaty. Now, with the Constitution, the constituting authority is no longer the states, it is the people. Adams wrote to his friend Richard Henry Lee of Virginia in December 3rd, 1787, quote, "As I enter the building, I stumble at the threshold. I meet with a national government instead of a federal union of sovereign states. I stumble at a smaller threshold, one buried in Article 3 of the Constitution, a smaller but nonetheless important threshold, for it raises the same question we the people raised for Adams, the question one then, and it remains for us today, the division of authority between, to use Adams' words, national government and the sovereign states. The smaller threshold is the word all, used 4 times at the beginning of Article 3, Section 2. Article 3, as you know, is the judicial article of the Constitution. It corresponds to Article 1, the legislative article, Article 2, the executive article. Article 3, Section 2 is closely analogous to Article 1, Section 8. Unlike state legislatures, those of you who are in the middle of common law will know this, unlike state legislatures, the American Congress is a Congress or legislature of limited powers. If you cannot find in the list of powers delegated or given, enumerated for the national government in Article 1, Section 8, or you cannot find it in the empowering clauses of the post-Civil War amendments, Congress simply has no power to legislate. Similarly, Article 3 lays out specific heads of jurisdiction. Federal courts are not courts of general jurisdiction as the state courts are, and if you can't find the head of jurisdiction in Article 3, Section 2, the federal courts are not empowered to act. The word all is a critical word as we go through Article 3, Section 2, laying out the heads of jurisdiction, and I will spend this lecture, Ernie's right, I cheated. I was asked what the title is. I wrote an email back saying, if I told them what this is really about, no one would come. So here's a snappy title, at least as federal courts people think about snappy titles. The true title of this article is the meaning of the word all as used 4 times at the beginning of Article 3, Section 2 of the Constitution. And I could say the question is like, what's the meaning of is? Well, I'm escalating it by 1 letter. What's the meaning of all? And when I get my courage truly up, I'll move on to 4-letter words, but I'll stick with all. Let me read Article 3, Section 2, Paragraph 1. Now, this is the article that gives generally to the federal courts, not specifically to the Supreme Court, but generally to the Supreme Court, the various heads of jurisdiction for subject matter jurisdiction. It begins, the judicial power shall extend to, and now we're going to get the phrase, all cases, repeated 3 times. All cases in law and equity arising under this Constitution and the laws of the United States, treaties made or which shall be made under their authority. I'll call that all cases arising under federal law, or we'll just call that federal question jurisdiction. To all cases affecting ambassadors, other public ministers, and consuls. I'll call that ambassador jurisdiction. To all cases of admiralty and maritime jurisdiction. I'll call this admiralty jurisdiction. The first paragraph then continues with more heads of jurisdiction, but I'm warning you what's going to come. The word all is going to be dropped, and the word cases is going to be replaced by the word controversies. Don't worry about the change from case to controversy. Cases to the framers meant civil and criminal. Controversy to the framers meant civil. That's not the focus of what we're about, so we can put that off to one side. But the paragraph then continues without the word all. The judicial power shall extend to controversies to which the United States shall be a party, to controversies between 2 or more states, between a state and citizen of another state, between citizens of different states, and so on. Party-based with controversies without the word all. Then, the second paragraph of Article 3, Section 2, more specifically sets forth the jurisdiction of the United States Supreme Court. It provides that the Supreme Court shall have original jurisdiction, that is to say, the Supreme Court shall act as a trial court for 2 categories of cases: ambassador cases, same case we heard before, and cases in which a state is a party, which is several of the jurisdictions we heard before. And as to all other categories of cases, the Supreme Court's jurisdiction shall be appellate. And let me read this. This one's a shorter paragraph. In all cases, here we are again, in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction with such exceptions and regulations as Congress shall make. The word all thus appears 4 times in the first paragraph for federal question jurisdiction, ambassador jurisdiction, and admiralty jurisdiction. It then appears again once in the second paragraph, specifically describing the United States Supreme Court's original jurisdiction, all cases involving ambassadors, and all cases in which a state shall be a party. And if you add up the various heads of jurisdiction, you can see ambassador jurisdiction was repeated twice. So in fact, we have only 4 heads of jurisdiction, adding the 2 paragraphs together, in which we have the word all: federal question, ambassador, admiralty, and states shall be a party. What's the significance of that word all? The most interesting thing in a way is its almost invisibility in the analysis given to Article 3 and to the structure of the federal judiciary in the 200+ years that we've seen. There's very little discussion of it, almost none in the Framing Convention. There's a little, but only obliquely in the Federalist Papers. There's a little bit when the first serious act was passed granting general federal question jurisdiction in 1801, repealed a year later. It's discussed at some length, although somewhat confusingly by Justice Story in his great opinion in Martin v. Hunter's Lessee in 1816. What's at stake with the word all? In a sense, the converse is at stake now from what was at stake at the beginning. At the beginning, what was at stake for all of the framers was, to what degree should the jurisdiction of the state courts be taken away and exercised by the federal courts? That was a question of enormous controversy, and the states' rightsers fought strenuously against the Federalists so that the states would retain as much as possible of their original, or what they would call primitive or primordial jurisdiction. Today we have the same discussion, although it tends to go in the converse. That is to say, we are now so accustomed to the federal courts having extensive jurisdiction, we worry about, instead of stripping jurisdiction away from the state courts, as the Federalists worried about at the beginning, we now worry about stripping jurisdiction from the federal courts and giving it to the state courts. This jurisdiction stripping, particularly in the later part of the 20th century, showed up several times when the United States Supreme Court issued opinions that were unpopular. School prayer, abortion, busing. Every time we got one of those hot-button issues decided by the Warren Court on the liberal side, there were threats in Congress to take away federal court jurisdiction so that those questions could not be decided by the federal courts, but would instead be decided by the state courts, as a way of simply disabling the federal courts from having a uniform mechanism for enforcing what had become the constitutional law of the land under the federal Constitution. So the word all may figure prominently in the debate. Originally, how much is taken away from the states, and now, if possible, how much might be taken away in the opposite direction from the federal courts. Despite its prominence, the word has received so little attention it is almost startling. Everyone, or almost everyone, instead of stumbling at the threshold, seems to have stepped easily across it without even noticing the word. Joseph Story paid attention to it and wrote a fair number of paragraphs in Martin versus Hunter's Lessee. That great modern iconoclast, Professor William Krosky, paid some attention to it. Professor Akhil Amar, more recently, beginning in 1985, has paid close attention to it. And let me focus on Professor Amar's interpretation of the word, both in terms of what he says and what it might potentially mean. Professor Amar reads that word, all, in the first three instances, the general jurisdiction, federal question jurisdiction, ambassador jurisdiction, and admiralty jurisdiction for all of the federal courts, as requiring Congress to confer upon the federal courts every jurisdiction over every case involving federal law, ambassadors, or admiralty. Now, it doesn't matter that the case might start out in the state court, so long as it can go up an appeal or certiorari to the United States Supreme Court, or it's enough if it goes into the federal district court and works its way up, but there must be jurisdiction in some federal court over every case in that category. That's his reading of the word. Now, there's some very serious problems with the word because it's never been entirely construed that way, even at the beginning under 1789 of the Judiciary Act, where the full extent of the federal question jurisdiction was not given. Section 25 of the Judiciary Act of 1789, for example, gives appeal to the United States Supreme Court over cases coming up from the state courts, but only when the state court decided adversely to the federal right asserted. If the plaintiff who's asserting a federal right in state court wins, no appeal. So you automatically say, well, that doesn't sound like all cases in which a federal question arises shows up in the federal court because there's no appeal. You can't come up from the state court in that circumstance under Section 25 of the Judiciary Act. The great advantage to Professor Amar's reading, at least from a certain perspective, is that it severely constrains the power of Congress to strip the federal courts of jurisdiction because, you read the word all, it says all questions arising under federal law must come into the federal court at some point, either originally in the district court or potentially on certiorari to the United States Supreme Court. So there's an interesting political consequence to that reading. I think that reading is wrong. I think it is flatly wrong, runs against the historical evidence, and instead of construing it that way, here's what I think is in fact the most natural reading. Surprising to me that no one since, depending a little bit on how you read Joseph's story, if you read him one way, no one since 1816 has suggested it, or if you read him another way, no one since 1801 has suggested it. Yet it seems to me that the historical evidence is overwhelming in favor of the following reading. I think the word all means that Congress has the power under those three heads of jurisdiction to make federal jurisdiction exclusive. That is to say, you can have all of the cases arising under federal law or any subpart of federal law exclusive in the federal courts so that they can never go into the state courts. So that, for example, modern statute would be patent law. If you want to prosecute a patent, if you want to charge patent infringement, the only place you can go is federal court. Or admiralty. Since 1789, the only place you could bring an admiralty suit was in the exclusive jurisdiction of the federal courts. That reading means all, and I think the most literal and obvious sense of the word all, if Congress has exercised its power under any of those heads of jurisdiction, federal question, ambassador, admiralty, or state as a party, all of those cases can come into the federal courts and only into the federal courts. None of those cases can go into the federal courts. And in the time available to me in a lecture, I've gotten this all written out, but it's much easier if I talk it. I'll try to give you the supporting evidence for my reading of that term. Let me start out with the Constitutional Convention itself. The Constitutional Convention is actually rather unhelpful. I read through in preparation for the article, or this talk, all of the Farrand sort of debates of the Constitution that have been preserved. And I agree with Professor Julius Goebel, who writes in his Holmes Devised History as to Article 3, the judiciary was subjected to a much less critical working over than the other departments of government, which I think is right. You get a lot more talk about Article 1, a lot more talk about Article 2. And then Goebel goes on, certainly when specific provisions were under discussion, there was precious little divulged. Well, there was almost no open debate, at least none recorded, about the federal court's jurisdiction during the convention. On July 18, it was unanimously resolved, quote, that the jurisdiction of the national judiciary shall extend to cases arising under laws passed by the general legislature and to such other questions as involve the national peace and harmony. Well, that's a nice inspirational sort of general guidance, but it's hardly a specific direction from the framers as to how those courts ought to be established. There was a significant fight at the beginning as to whether or not there would be only a United States Supreme Court and all the rest of the business of the new national government should be carried out in the state courts, or whether there should be an automatic constitutional creation of not only the United States Supreme Court, but also the lower federal courts. That was resolved by a compromise introduced by James Wilson of Pennsylvania, originally from Scotland, and Madison from Virginia. Now, I don't know why Wilson doesn't get any credit. It's now commonly called the Madisonian Compromise. But under the Madisonian Compromise, the Supreme Court is created by the Constitution. It is then given to Congress to decide whether to confer jurisdiction on, whether to create and confer jurisdiction on the lower federal courts. And they can confer as much or as little as they like. Now, there's a very prominent role played by James Wilson, not only a delegate to the convention, but also one of the first justices on the Supreme Court. Wilson is a member of the Committee of Detail, which was charged with giving final form to the Constitution. And among his papers is a draft in his hand with emendations by Edmund Randolph of Virginia, also one of the other 5 members of the Committee of Detail, which he lays out in what is quite close to the final form that I just read you of Article 3, Section 2, paragraphs 1 or 2. The primary difference is in this paper, undated, is that at that point it's only the Supreme Court. And at that point the courts have, in addition to the jurisdictions I've read to you, the Supreme Court also had jurisdiction over impeachments. And of course it ends up without a jurisdiction over impeachment. And of course we end up with the possibility of creating lower courts. On August 16th, the Committee of Detail provides its draft of the entire Constitution in the form of the draft that I've just summarized or described to you. On August 27th, the entire convention votes on various amendments. They sort of go through clause by clause by clause, at which point it adopts almost the final form that we have. And on September 8th, the Committee of Style reports it to the convention in virtually the same as we have it, except for one thing, between the final approval of the draft by the Committee of Style. So Committee of Detail works out the detail, Committee of Style kind of works out the last polishing, but even after that is finished, the word all is added to the original jurisdiction of the Supreme Court. The word all was there with respect to the general heads of jurisdiction, federal question, ambassador, admiralty. That was there from very early on. But the word all is added at the very last minute for the Supreme Court's jurisdiction, and then the Constitution is approved finally on September 17th. We have a hint that the word all might mean what I've suggested it means from a brief statement by James Wilson during the convention in which he says, as an argument for why you want lower federal courts, district courts, and courts of appeal, he says, well, admiralty has to be exclusive in the federal courts because of its nature. So we know that he's thinking exclusive jurisdiction for admiralty, but I have to say it is not much more than a hint. Let's turn next to the Federalist Papers. Now, that's an odd place to look to for sort of authoritative construction of a technical point. Number one, because it's written for a general audience, and number two, because, of course, despite the eminence and thoughtfulness of the authors, they are writing propaganda. Nonetheless, if we look at Federalist 82, written by Hamilton, we'll see that he specifically takes up the question of exclusive versus concurrent jurisdiction. He never mentions the word all, and the overlay of his categories is slightly different from the categories that we actually see in the Constitution. But he says that, well, you need to have exclusive jurisdiction for certain categories of cases. For example, you need to have at least the potential for exclusive federal jurisdiction for cases arising under federal legislation. He says, now, before the adoption of the Constitution, of course, there was no such thing. There was no possibility of federal legislation. And that the federal courts should at least have the potential, if Congress gives it to them, of exclusive jurisdiction over cases arising under federal law. The Constitution should and does give that to them. On the other hand, says Hamilton, as to cases between, for example, a citizen of Virginia and a citizen of New York, as to which the states had perfect jurisdiction before the creation of the national republic, well, they should continue to have jurisdiction, and there should be no possibility of exclusive jurisdiction in the federal courts over such cases. Stated roughly, and to repeat it, the states should be able to retain, at least in concurrent form, their primitive or primordial jurisdiction. That is to say, the cases that they would have had jurisdiction over in the absence of the Constitution, they have to be able to keep those cases, at least concurrently with the federal courts. However, the cases that are created by virtue of the creation of the new national government, now those can be made exclusive. Not that the Constitution itself makes them exclusive, but Congress has the power by statute, if it chooses, to make them exclusive. Now, Hamilton never mentions the word all, doesn't get down into the specific heads of jurisdiction, and in fact, if I were really to go at him in detail, I would say that he misreads slightly a couple of them, but the general principle is very clear that he's arguing for. The next piece of evidence, I think, is probably the most persuasive evidence, and that's the original Judiciary Act. Immediately after the Constitution is ratified, Congress gets down to business, and in the fall of 1789, during its very first session, it passes the Judiciary Act of 1789. And it creates district courts, circuit courts, and confers some jurisdiction on the United States Supreme Court. I don't say it created the United States Supreme Court because it was then assumed, and we continue to assume, the Supreme Court was created by the Constitution, although some of its jurisdiction requires that the Congress confer it. So what happened in the Judiciary Act of 1789? First, in Section 9 of the Act, Congress creates the district courts, the trial courts with a single judge. What jurisdiction was given to the district court? Exclusive jurisdiction over some federal crimes. Federal crimes, of course, arise under federal law. Exclusive jurisdiction over suits against consuls or vice consuls, a subcategory of the ambassador jurisdiction. An exclusive jurisdiction with the, if you're an admiralty buff, subject to the famous saving to suitors clause, exclusive jurisdiction over admiralty cases. So the federal district judges get exclusive jurisdiction over all three heads in Article 3, Section 2, Paragraph 1. They get exclusive jurisdiction over some federal question cases, exclusive jurisdiction over some ambassador cases, exclusive jurisdiction over some admiralty cases. Not exclusive jurisdiction over all, but exclusive jurisdiction over some. Second, in Section 11 of the Act, Congress creates the circuit courts. Now, don't think of the circuit courts then as we think of the circuit courts now. Circuit courts now are courts of appeal. Circuit courts then did have appellate jurisdiction coming up from the district court, but by far the most important part of their jurisdiction, they were trial courts. They were trial courts with 3 judges, sometimes 2 because sometimes the Supreme Court justices couldn't or didn't want to show up, but they were trial courts primarily hearing diversity cases with amount in controversy over $500. That is to say, important commercial cases could come into the United States Circuit Courts, but only concurrently. That is to say, this was not exclusive jurisdiction in the federal court. If you had a diversity case between a citizen of Virginia and a citizen of New York and the value in controversy was over $500, you could file in the state court. That jurisdiction could not be taken away. That's the Hamiltonian theory, and I think the theory of the Constitution. But you could also file in federal court if you chose. Third, in Section 13 of the Act, the Supreme Court is given original, that is to say trial court jurisdiction, over suits against ambassadors and public ministers, so ambassador jurisdiction, and they are given exclusive original jurisdiction over suits between 2 states. So we now have exclusive jurisdiction in that last clause. We did federal question, ambassador, admiralty, that's paragraph 1, but then we get that add-on of state as a party under the heading of all cases for the second paragraph, and sure enough, the Supreme Court is given exclusive jurisdiction over suits between states. Now, suits between states encompass more, the state as a party jurisdiction that's potentially exclusive under the jurisdiction given to the Supreme Court is broader than merely suits between states. It could be between a state and a citizen of another state, which is another clause of the Constitution. That, however, is not given exclusively, it's given concurrently. I have to say that the congruence between the use of the word all in Article 3, allowing Congress to give exclusive jurisdiction to these 4 heads of jurisdiction, federal question, ambassador, admiralty, state as a party, and the Judiciary Act of 1789, which does exactly that as to subcategories of each one of those heads of jurisdiction, seems to me a fairly strong argument in favor of the word all, meaning potentially exclusive jurisdiction in the federal courts. Conversely, the fact that all of the rest of the jurisdiction conferred upon the federal courts is concurrent, including the diversity jurisdiction, which I'll go back to Hamilton for a moment, could not be given exclusively to the federal courts, carries with it then, when the word all is removed, there's a negative pregnant. That is to say, you don't have jurisdiction. You can't confer exclusive jurisdiction over any of the cases in which the all are controversies, to which the word all is not appended. There is further evidence, although slight, when in 1801, the outgoing Federalist Congress is doing its best to preserve the power of the new central government. As you'll recall, President Washington is succeeded by the first President Adams. Adams is defeated by Jefferson, and the incoming Jeffersonians are ardent states' righters. After the election, the outgoing Federalist Congress passes a statute conferring broad general question jurisdiction as a trial matter on the federal courts and creates for the first time a genuine circuit-riding Court of Appeals. That statute's repealed a year later, and the federal judges on that new Court of Appeals are thrown out of jobs, which seems to me to have created a constitutional question that they seem to have been able to get past. But for our purposes, it's not the enacting and then the repeal, but rather simply a statement by one of the people debating that article, and that's Mr. Abraham Knott of South Carolina, who is recorded in the Annals of Congress as standing up, he said, so I mean it's a little different from our locution. This is Knott. Knott could see no reason why the word all was added in the former part of the section and omitted in the latter, except it meant that there was no case of the former description to which the judicial power should not extend. In fact, the courts of the United States should have exclusive jurisdiction over all those cases. And in the latter, where the word all does not appear, their jurisdiction should be concurrent with that of the states. It was further to be observed, he said, that the first description of cases here enumerated, that is to say with the word all, were such as had received their birth from the Constitution and laws of the United States and could not have existed previous to the establishment of the government. But the latter were such as the individual states might have had jurisdiction previous to that period. In other words, it's a very precise description, now invoking the word all, that corresponds to the Hamiltonian explanation in Federalist number 82. Next, I want to talk about Joseph Story. Now, I want to take just a moment before I get to his famous opinion in Martin versus Hunter's Lessee and say a word about Joseph Story. He has been terribly maligned over the last 100 years. He was the author, as I'm sure all of you know, or at least can be reminded, of the famous case of Swift versus Tyson, decided in 1842. Swift versus Tyson, which, as it's latterly characterized, gives us the general common law, that horrid beast that allowed the federal courts to oppress poor people, protect railroads, and everything else, which was finally and mercifully overruled in Erie versus Railroad, Erie Railroad versus Tompkins in 1938. That's the story. In order to overrule Swift versus Tyson, the bad people at the Harvard Law School, led by Horace Chipman Gray, author of a treatise on the rule against perpetuities, for which he is justly famous, his assassination of Joseph Story, I would say justly infamous, they felt it necessary not only to say that Swift versus Tyson wasn't working very well, that should be enough. They felt it necessary to say that Swift versus Tyson was wrong when decided, and wrong when decided by this evil genius of the nationalizing government, a man famous for glittering generalities. The first place I ever read that word was in John Chipman Gray in 1907, criticizing him as writing in glittering generalities, famous for knowledge even beyond that which he had. I mean, it's just straightforward. I mean, if you think political campaigns are dirty, this one was even worse. Story has hardly recovered his reputation from that attack. Yet I have to say that he was one of the great intellectuals of his period. And his decision in Swift versus Tyson, I have to say, was entirely in accordance with the common jurisprudence of the time. Absolutely, there was no new law made in Swift versus Tyson whatsoever with respect to the general common law for which he was later attacked. But Story was a great centralizer. He was a great believer in the beneficial power of the federal courts, particularly in diversity cases, so that the federal courts could help bring uniformity to the common law, the commercial law among the several states. That's what he wanted to do above all. By happenstance, he gets to write a famous opinion, Martin versus Hunter's Lessee. The issue in Martin versus Hunter's Lessee is whether or not Section 25 of the Judiciary Act is constitutional. Section 25, as you may recall, that's the section of the Judiciary Act that gives to the United States Supreme Court appellate jurisdiction over the decisions of the state courts. Virginia Supreme Court said, sorry, it is unconstitutional, we are a sovereign state. The United States Supreme Court cannot have appellate jurisdiction over any of our decisions. Of course, that seems to us ludicrous, seemed to the United States Supreme Court at the time at least wrong. But the happenstance is that John Marshall, then, and had been for some years by then, the Chief Justice, and who was in the habit of writing every opinion for the United States Supreme Court while he was chief, he was financially interested in the suit. He was a land speculator. He owned some of the land in dispute, so he was recused. Interestingly, he appears to have written some of the papers by the parties in that case, in the case appearing before his court, so he was really recused. He had become a genuine lawyer. But Story gets an opportunity finally to write an opinion. Meanwhile, he's been writing treatises. He writes many lower court cases. He's sort of, as it were, commissioned his own reporter so that his his decisions on the circuit court are reported. But he finally gets to write one. And he does, you know, it's his only chance, right? So instead of just saying we have appellate jurisdiction over the Virginia Supreme Court, he has a long exposition as to the nature of federal jurisdiction. And he argues that the words that begin Article 3, Section 2, that say the judicial power shall be vested, he argues that that means that the federal courts constitutionally are required to be given jurisdiction over every case, and controversy listed there. Not merely the 3 alls at the beginning, not merely federal question, ambassador, and admiralty, but diversity cases. He says judicial power shall be vested means every head of jurisdiction that goes down that list must be given to the federal courts, required by the Constitution. He then discusses the word all, but his use of the word all is to say that with respect to cases in which the exclusive jurisdiction is authorized, well, as to those cases, you're going to have to create lower federal courts if that jurisdiction is going to be exercised properly. So he focuses on the word all, but he focuses on it by saying that is where exclusive jurisdiction may be necessary, and if you're going to have it exclusive, then you have to create the lower federal courts. That opinion has been a puzzle to most people because they don't understand that the word all is the key to the word, to the meaning exclusive. Now, you have to take Story with a grain of salt. He was famously such an advocate, for example, of federal admiralty jurisdiction. It was said of him, I mean, it was a joke, of course, if he saw a corn cob in a bucket of water, he would declare the admiralty jurisdiction covered it. It's been argued by modern scholars that Martin versus Hunter's Lessee in that argument is Story wanted the federal question jurisdiction to be all, and he cared little about the rest of it. That's precisely backwards. What Story wanted more than anything else was federal question jurisdiction over the diversity cases, because there was where the commercial life of the country was, and there was where the uniformity that the federal courts could provide for us. It goes along with that in a separate essay he wrote, and then repeated every time he got to speak to the local Kiwanis Club. He wanted the last sentence of the Section 25 removed, because that last sentence, I'm afraid this is getting deep into federal courts, but sorry, you came to the lecture and you ate the food, so you're... That last sentence said that the appeal shall be resolved looking only at the federal question that is the source of the jurisdiction. In other words, if there's some questions of general contract law also involved in the case, couldn't hear them. Now, that sentence was removed under circumstances that all we know it was removed after the Civil War. And then the question of what's it mean that it was removed? Justice Story finally got his wish. And, well, once he finally got his wish, of course, he died in 1845. And we get Justice Miller then on the Supreme Court absolutely hating the expansion of federal jurisdiction at all, because it was being used to penalize, as he viewed it, the innocent farmers in Iowa. So he said it makes no difference that it's gone. But my point is that Story was terribly, terribly interested in the expansion of the federal court's jurisdiction over commercial cases. He could have cared less about civil cases under federal law because there was so little federal law. So Story, I think, fits in fairly well with the thesis. If we move to the modern statutory structure, it's as if we've got someone blindly reading the word all properly without quite understanding the significance of the word all and how we get there. The modern statutory structure that we have today matches conceptually exactly the statutory structure of the Judiciary Act of 1789. We've greatly expanded the federal question jurisdiction that is exclusive. So we not only have federal crimes, we've got federal securities, we've got bankruptcy, we've got patent, we've got antitrust, we've got most ERISA cases. Oh my God, I hate those cases. Natural Gas Act. We've got a lot of exclusive jurisdiction in federal question cases. We continue to have ambassador jurisdiction, both in the federal trial courts and in the United States Supreme Court. We continue to have admiralty jurisdiction. We have exclusive jurisdiction in the United States Supreme Court over suits between states. We have, in other words, almost exactly, although slightly expanded, conceptually exactly the jurisdiction given by the Judiciary Act of 1789, where the word all authorizes exclusive jurisdiction, and we have never had an attempt to confer exclusive jurisdiction over any of the heads of jurisdiction not preceded by the word all. Now, what does that do to the jurisdiction stripping idea with which I began? Does it make any difference? Well, it potentially does make a difference. If I'm right, and if we follow that as the constitutional construction, we no longer have, as a constitutional argument, that Congress must confer on some federal court the full extent of the federal question jurisdiction. Congress may be restricted in other ways from limiting that jurisdiction, but the most general power of taking it away now exists. Now, I would respond to Professor Amar, who dearly loves his theory and dearly loves the argument that it would prevent certain forms of jurisdiction stripping. I would respond to him with a line from Jake in The Sun Also Rises. He says, "But wouldn't it be pretty to think so?" Well, yes, it might be pretty to think so. On the other hand, let me give you another vision that I think is equally as pretty. And I'll take this from one of my heroes, probably heroes to Judge Levy and Professor Young as well, Charles Black, for whom I was many years ago a teaching assistant. He wrote a book called The People and the Court. And he begins the book, I think he made it up, but he begins the book with a Frenchman coming into New York Harbor on a ship, smelling the air, saying the sweet air of legitimacy. Well, I'm not sure what he was really smelling as they came into New York, but the theory was he was coming into a land where the courts had legitimacy. One of the ways that we can give legitimacy to our courts is to say Congress has the power, if it chooses to exercise that power, to restrict the jurisdiction of the federal courts, and it has not. So long as it has not, we may understand that there is not only ordinary legal legitimacy, but political legitimacy for what the federal courts are doing, and I think it's pretty to think that also. So thank you very much.
Thank you, Judge Fletcher, for that wonderful lecture. We have a reception outside the classroom. If you would like to ask Judge Fletcher some questions, you can do so outside. Thank you very much for coming. We're adjourned.